Pursuant to the adjournment, the Honorable David C. Mason is presiding. Good morning, Your Honor.
Good morning, Counsel. You may all be seated. All right. Court calls the matter of Circuit Attorney of 22nd Judicial Circuit, ex-rel, Lamar Johnson. This is cause 2222-CC09375. This cause is before this court pursuant to a motion of the Circuit Attorney on behalf of the relator to ask the court to revisit issue of whether the defendant may be actually innocent pursuant to Missouri statute. Let the record reflect that, well, I have so many attorneys, why don't you just each announce yourself for the record. Let's move left to right. Go.
Thank you, Your Honor. Tristan Eastep on behalf of the state of Missouri with the Attorney General's Office.
Good morning, Your Honor. Miranda Ledge on behalf of the state of Missouri through the Missouri Attorney General's Office.
Assistant Attorney General Andrew Crane. Greg Goodwin from the Attorney General's Office.
Good morning, Judge. Lindsay Reynolds on behalf of Lamar Johnson.
Jonathan Potts, prosecutor on behalf of the Circuit Attorney's Office.
Charlie Weiss, Your Honor, on behalf of the St. Louis Circuit Attorney's Office.
Elena McMullen on behalf of Lamar Johnson.
Good morning, Your Honor. Sue Gardner, Circuit Attorney for the City of St. Louis.
Good morning, Your Honor. Serena Wilson with the St. Louis Circuit Attorney's Office.
All right. This motion is advanced, obviously, by the Circuit Attorney. So therefore, I'm sorry, I didn't see you guys right there. Go ahead.
Matthew Jacober on behalf of Lamar Johnson.
Trisha Rose Bushnell on behalf of Lamar Johnson.
Are all those who are announcing on behalf of Lamar Johnson employed through the Innocence Project?
I am, Your Honor.
I'm not, Your Honor. I'm a partner of the law firm of Wakefield QCM, as is.
All right.
Coleman is an associate.
So you're the only person from the Innocence Project?
That's correct. I'm employed, but our pro-bono partners are doing it.
All right. Barry Sheck's an old friend of mine, so I'm going to tell you how you do. I'm going to report it directly to Barry, so you better be, all right. All right, this sounds good. Since Circuit Attorney is advancing the motion, I will allow both sides to give me a general opening statement. Since Lamar Johnson is the real party in interest, keep in mind that I might allow his direct representation. I did not see in the statute, however, somebody correct me if I'm wrong, where there's a provision for direct representation of the relator, what I now define as the relator given the nature of the statute. So I'm going to look at the principal attorneys as attorneys representing the Circuit Attorney, since the attorney is the movement on behalf of the relator. And then I'll be looking at the Attorney General, since the statute does seem to allow an opportunity for the Attorney General's office to respond. You're probably sitting at the wrong table, so I think I can work it out mentally. That being the case, then, counsel for the Circuit Attorney's Office, you have leave. Hold on, let me get I need a notepad. I thought I had one up here.
And Judge, if I may, before we begin, the state of Missouri would like to invoke the rule.
Okay, is there anybody in my courtroom who has been told that they might be a witness in this case? This is all I have. I have a notepad in here.
I can get you one.
Please do. Let me look for anybody in the court. Okay, those of you who've been told you might be witnesses, could you please leave the courtroom?
Judge, Lamar Johnson is going to be.
Oh, he's a party.
Of course, but
Real party in interest, actually.
And it's the court's ruling regarding the principal attorneys that Mr. Johnson's counsel.
No, witnesses.
Okay.
The rule of sequestration is only witnesses.
No, Judge, of course. I was wanting to clarify. I understand the principal attorney's ruling. Does the court anticipate permitting Mr. Johnson to make any questions that he feels is necessary of a witness, limited though it might be?
I'll have to think about that. A lot depends on how I see the testimony develop. I'm not interested in cumulative evidence, all right? If you feel that the attorney representing the Circuit Attorney's Office has missed the boat on something, your first step should be to lean over to them and tell them. If there's a dispute between you, but you think it's important in terms of the interest of your client, then ask permission to inquire of the witness. Under that standard, I'm not going to give it to you. Has everyone left the room who thinks they might be a witness? All right. Give me a minute to take a look at these faces. Because anybody who walks up to be a witness that I see right now, you will not be allowed to testify. So attorneys, you better make sure you don't have a witness sitting out there. I'm bad on names, great on faces. All right. Then, of course, the rule of secretariat is going to be granted. Anything further before we begin?
No, Judge, thank you.
All right. Counsel for the circuit attorney, you have leave to give opening statement to the court.
Thank you, Your Honor. May it please the court. This is a rather historic moment in this court. This is the first time in the history of the 22nd Judicial Circuit where the court is hearing an actual innocence claim filed by a prosecuting attorney. This case began in 2019 when the circuit attorney filed a motion for a new trial for Lamar Johnson. The case arose out of the circuit attorney's conviction integrity unit, where they reviewed cases to see whether or not any case in the past was wrongfully decided or an innocent person was convicted. They determined in this case that Lamar Johnson was innocent. However, this circuit court, not you, Your Honor, dismissed the case because there was no rule that allowed a prosecuting attorney to file a motion for a new trial 20-some years later after the conviction. You can file a motion for a new trial, but it has to be filed within 15 days of the conviction. Now we're talking about 20-some years. The case was appealed to the Court of Appeals here in St. Louis, and they affirmed it in a per curiam opinion in December of 2019. It went up to the Missouri Supreme Court. Missouri Supreme Court in March of 2021 affirmed it also, but several opinions were written in the case, some concurring opinions, some dissenting opinions, but there was a suggestion that there was a real need for a rule or a statute. Sure.
Did the Supreme Court publish its opinion?
They did, Your Honor.
All right.
They did. I don't have the citation, but it's State of Missouri versus Lamar Johnson, and it was issued in March of 2021.
Can anybody give me that citation? Any attorney?
I may have that. I think I do.
I'm sure it's buried in the briefing, but
I have a copy of the opinion, Your Honor. It was. Don't have the citation, but I'll give you my copy if you want it.
any problem with me giving you this copy? Counsel,
No, Judge.
you what says all these notes vote for us.
We trust you, Judge.
Thank you very much. I'm going to leave this. Go ahead, Counsel.
So as a result of that, so they suggested that this matter be resolved by the legislature. As a result of that, a new statute was drafted and passed by the legislature in August in 2021. A number of people in the room here were involved in drafting that statute. The first case that was tried under that statute was the Strickland case. It was tried last year in Jackson County, Missouri, and the person was found innocent. We filed this case on behalf of Circuit Attorney's Office in August of this year.
Did you proffer in any other briefing in the Strickland case, the judge was finding the fact that the students involved, assuming that they were that such document being done?
I did not, but Ms. Reynolds probably can tell us.
There was a finding of facts and conclusions
You
of
have a
law.
copy of that, right?
We get one, Judge.
All right. You can go ahead and look for it while he can check with his open. Go ahead, Counsel.
So this statute that we're pursuing today is the innocent statute, and it's section 547.031, and we've attached it or quoted it in our motion to vacate, Your Honor. And basically it says that a prosecuting attorney in any jurisdiction in Missouri in which a person was convicted of an offense may file a motion to vacate or set aside at any time if he or she has information, not evidence, information that the convicted person may be innocent and may have been erroneously convicted. In that case, then, the court shall grant an evidentiary hearing, which you're doing today, Your Honor, to vacate or set aside the judgment where the court finds that there is clear and convincing evidence of actual innocence or constitutional error at the original trial or plea that undermines the confidence of the judgment. In considering the motion, the court shall take into consideration the evidence presented at the original trial, the evidence presented at any direct appeal or post-conviction proceeding, including state or federal habeas actions, and this is important, Your Honor, the information and evidence presented at the hearing on the motion. The reference to information was specifically included in the statute so that in the search for justice and truth, we didn't get hung up on technical evidentiary rulings. So in this case, before you, Your Honor, you're entitled to consider any information and evidence presented at this hearing. I want to talk a little bit about the crime scene itself that we're having a hearing on today.
Before you go in, this is not a trial they don't know, right?
I understand.
So make sure that you only discuss those things which might cause a reasonable judge to consider the possibility of actual innocence. All right, go.
Okay. I think to do that, Your Honor, I want to talk a little bit about the crime itself. Because the evidence that convicted him, convicted Mr. Johnson, included an eyewitness testimony. And of course, I want to talk a little bit about how questionable.
Do we have the transcripts? I'm sure you do. I'm just asking. The transcripts of the pivotal witnesses in the trial below?
I think, Your Honor, we attached the transcript of the trial to our motion.
Right. Don't expect the judge to do work for you. You've got to give me those excerpts from the testimony that support your position. Same thing for the Attorney General's office. All right? Don't expect me to go through it all, try to figure out what goes this way and what goes that way. You do your work for you.
Sure, Your Honor.
You do your work, I'll read your work.
Sure, absolutely. Jonathan, can you bring I want to show the court a little bit to understand what's happening here. We have a picture of the actual crime scene where this occurred. It occurred, Your Honor.
Do I need to be able to see this screen? I guess I do. Hold on. Can you do this? I guess if we set it on that, it would stay connected. Yeah, because I don't think I'm going to be used for it, but it blocks my view to this one. I'll tell you what, you see those two wires there?
We can bring that over here, Your Honor, where you can see it. Does that make it better for you?
Yeah, what about that monitor over there? Did it move?
Yes, that monitor moves, Your Honor.
Okay, just push it out of the way so you can, and then we'll just go from there.
Bring it.
All right, Counselor, you can come up here now. Thank you very much.
So what you're seeing, Your Honor, is the actual house on Louisiana, 3910 Louisiana, where the murder occurred. This fence and gate was not present at the time. This picture was taken long after the accident, the incident. But it occurred at 9 p.m. at night on October 30, 1994, the day before Halloween. It was dark. There were no street lights illuminating this court. The only light that was illuminating it was there's a stairs that comes down from this door. The door was open, the screen door, the door was open, the screen door was closed. So you could see a little bit of light from the
Single family home or?
This is a two-family, Your Honor. One goes upstairs here, and this door here was the ground floor.
Gotcha. Okay.
So on that day of October 30, 1994, Howard Johnson who's going to be a witness here, and Phil Campbell, who's no longer living, Your Honor, got together that day and they started talking about a number of things, but one of the things they talked about at the end of the day was one of their friends were with them. By the way, they lived at 3944 up the street from this house at 3910. And Cerrone Spates had been working with Marcus Boyd, the victim in this case, selling drugs. Thought he had been cheated in receiving some of the funds. So he was in a neck brace and wasn't in very good shape. So his buddies, Howard Johnson and Phil Campbell, decided that they were going to go down, teach Mr. Boyd a lesson, and rob him because he owed Buffy Spates money. So that evening, a witness in this case, somebody a witness today maybe, James Gregory Elking, who also had bought drugs from Marcus Boyd, went over to Boyd's house that evening to see if he could get some drugs. When he got there, Marcus Boyd was not there. So while he was there waiting, but he waited, and Marcus Boyd and his wife, Leslie, had just returned from grocery shopping. They saw Elking there and said, wait a minute, we'll put the groceries away, which they did, and Marcus Boyd came back downstairs, and Elking and Boyd sat on the porch talking. At around 9 o'clock, Mr. Howard and Mr. Campbell leave the back door of his mother's house, the lady's mother's house, walk down an alley behind this house, and come up the side alley here, and go up the steps. Elking is sitting there, Boyd is sitting there, and before you know it, one of them grabs Elking and pulls him down the bottom of the steps. The other two, in effect, shoot Boyd. This all happens in a matter of seconds.
Stop right there. You said the other two shot Boyd.
The two...
The evidence showed that Boyd suffered wounds from two different firearms?
Yes, Your Honor, a 25 caliber and a 38 caliber.
All right.
So both of these gentlemen, Howard Johnson and Phil Campbell, James Howard and Phil Campbell, shot Mr. Boyd. But the important thing is, it was dark, and both assailants wore masks, ninja-type masks, and all you could see were their eyes, not their nose, not their chin, nothing. And they all had black or dark clothing on.
Back up for just a second.
Sure.
I missed something you said.
Sure.
Were you telling me that while Elkin and Boyd were just talking with each other,
Yep.
two other unidentified persons?
No, no. The two persons were James Howard and Phil Campbell.
James Howard and Phil Campbell, but at the time they had the mask.
They both had masks on and dark clothing, ninja-type clothing. Sure.
Think about this, just tell me I tell the truth, we can't take notes.
You know, I have to take notes, Your Honor. I understand.
So at this point, evidence shows that these two individuals, James Howard and Phil Campbell,
Yep.
fully masked up, approached and shot decedent Boyd.
Several times they shot him, Your Honor. They then, obviously, as you can imagine, James Gregory Elking, who was just there to buy drugs, was traumatized. He thought they were going to kill him. They didn't. They pointed their gun at him. By how they walked down the step and walked back down the side of the house and got away. Mr. Elking ran as fast as he could.
Just a little, Counselor. I would be expecting the other attorneys to keep stay out of the crowd, because I see a lot of coming and going. You don't want to find yourself in a witness situation when you call a witness and I say, oh, I saw that person in front of us, and I don't allow them to testify. So there's enough lawyers where you can keep your eye open in case a witness comes walking in here. All right, go ahead.
So Leslie Williams, Marcus's boyfriend, had gone up to put the groceries away and also to change her, and give her little baby a bath. She heard the firearms being shot down here. She runs down the steps. She sees what's happening. She runs back and calls 911. That's how the police were called. She knew Elking was here because she saw him when they came home to put the groceries away. She could not identify any of the assailants.
Because of the mask.
Because of the mask and the darkness. It was dark. Yes, Your Honor. And she knew Lamar Johnson. Lamar Johnson, the innocent person in this case, had been dealing drugs along with Marcus. They lived together in an apartment for a couple months.
Stop where you're pointing. Did she say she saw Lamar Johnson?
No, she did not see Lamar Johnson. She could not identify the two assailants who had masks and dark clothing. She knew Marcus Johnson. She didn't say it. She saw Marcus Johnson there.
Wherever has your phone going, my bed is going to give you one strike on that. You can take my phone if it went off. I'm pretty sure I cut mine off. So make sure your phone is off, everyone. Go ahead.
So Elkins then is scared. He runs across the street, a couple of alleys back to his home, which is 3 or 4 blocks away. Tells his wife what happened, and they are really they're very afraid, and so ultimately they leave their house and move out to Limay with Mr. Elkins' sister, so that he was afraid that the two assailants saw him, they may come after him. So Leslie then told the police that she saw Elking there, and that she also told them that the only person that she knew might have a problem with Marcus, or Marcus might have a problem with him, was Lamar Johnson. But she never saw the two in any altercation or any physical violence or anything like that. She couldn't explain why, but she thought that Lamar might be the only one that might have a problem. So the police focused in on Lamar from the beginning. They also called Elking. And Elking and Marcus had worked together at the Sayre Printing Company at the time, down in St. Louis. But Elking didn't go to work. He was now afraid. So the police, Detective Nickerson calls over to Elkins, got a hold of his wife. His wife said that he's very afraid. He doesn't want to come forward. He's afraid they might be after him, kill him.
Hold on for just a moment, please. Count the bed.
Yes, Your Honor. So Elking, Detective Nickerson tells his wife that we want to talk to him. We'll get him. Tell him he needs to call us. So he called Detective Nickerson, and he said, I want you to come over to my house. I'll meet you somewhere. So they met at about 2 o'clock on November 3 at Country Buffet, a little restaurant. His wife. Okay. So that was the first meeting between Mr. Elking and his wife and Detective Nickerson. Elking will testify. He'll be here today or tomorrow. And he will say, look, I told them I couldn't recognize anybody. It was dark. They were wearing dark clothing, and they were wearing masks. Nickerson says, we believe you know who they were. We want you to come forward, and we'll give you protection if you're afraid so that you won't be harmed.
What was his protection supposed to be? It
I think initially they just talked protection or something like that. A witness.
Some type of witness protection program?
I think they're a witness protection unit. Our understanding now, Your Honor, I didn't know at the time, but I think neither did he. There was a witness protection unit in the prosecuting attorney's office.
And that, I think this may sound like dumb questions, but I just got to make sure.
Yeah, sure.
That protection was offered to Elkin?
To Elking, yes, Your Honor. So he said, would you take a look at some pictures? So Nickerson shows some Polaroid photographs, 5 of them, which apparently included Campbell and Lamar Johnson. Elking says, look, I told you I can't really see them. It was dark that night. They had masks on. So we'll just take a look at them. So Elking takes a look at the pictures, and he says, you know, this one, something about his eyes. His eyes look strange. And Nickerson said, will you sign the back of that photograph? And Elking said, no, I'm not going to sign anything. So Nickerson goes back to the office.
Elkin said the eyes in the photo look strange?
Yes.
But did he say the eyes in the photo he recalled as being the same as the eyes of one of his sailors?
Somewhere along the line, Your Honor, I don't know if it was this time or other, Elking says he thought one of them had a lazy eye. Now, neither the photograph nor Lamar Johnson has a lazy eye. But that's how he thought he recognized them initially. So Nickerson says, will you come down to the station for a lineup and view a lineup? And Elking says, sure. And so Nickerson goes back to the office and sends out a arrest warrant or a warrant to pick up Lamar Johnson.
They want to put him in the lineup.
And they want to put him in the lineup, I'm sure. And so later that day, the police stopped Lamar Johnson, who's driving a car, and with him is Phil Campbell. And they take them both down to the police station. This is like at night at 6 o'clock or later. And then he calls Elking, and he says, I want to come out and pick you up. We've got the people in the lineup. I want you to come down. So Nickerson goes out to Elking's house. Now they're out in the county in Lemay. Picks up Elking, picks up his wife, brings him down to the police station here in downtown St. Louis. They get down to the station. The police talk to Lamar and said, we're going to read you your Miranda rights. Lamar says, I'll waive my Miranda rights. I didn't do anything. I'll be happy to stand in the lineup because I wasn't there. They can't identify me. I wasn't there. So he said, I didn't do this, Detective Nickerson, period. In the meantime, he's in a room. Nickerson leaves the room and brings in another detective, Detective Ralph Campbell. Ralph Campbell starts questioning Mr. Lamar Johnson. No one else is in the room. No cameras, no recording, nothing. And now, in Ralph Campbell's story, and he wrote a little report on it, that while I was talking to Mr. Johnson, Mr. Johnson blurted out, I shouldn't have let the white guy live. That was his... Yeah, that's right. But remember, the witness, Elking, is white, Your Honor.
You just got told me that. Maybe you told me
I probably didn't tell you, but yeah, Elking was white. And so now, there's no recording of this. There's no statement of this. He didn't ask him to prepare a statement. And I don't even know if I guess he told Nickerson about it, but Nickerson at all times will say that Lamar has professed his innocence. He never admitted that he was there.
So just so I can tie this in, at that trial, this Campbell person,
he testified.
party point admission, testified, the defendant said to me, I shouldn't have let the white guy live.
Correct, Your Honor. That's right.
You guys going to talk to Campbell? Did we cross-examine him in this hearing?
Your Honor, it is our understanding that Detective Campbell, who was a 20-year veteran of the St. Louis Metro...
I don't need any credentials. My question was, are you going to proffer him to testify?
No, Judge. His health will not allow.
Can I make a comment? I wanted to talk to Ralph Campbell. called
You're
him.
not gonna be a witness, so don't say
I
no.
called him 12 times, July and August. Talked to his wife each time. His wife said, I'll have him call you. I talked to his son, who at that time was in Oregon. He said, I'll have my dad call you. And each time I called over there, they told me he was sleeping or was eating or something, and they'd have him call me back. I've not talked to him.
Give me just a quick second.
Sure.
Okay, Tom, you make your point.
Nickerson, there's no testimony that Nickerson ever heard Lamar make those comments, only Ralph Campbell. The trial, to put this in perspective, the trial lasted 2 days. Only 2 days. So we'll talk a little bit about what happened. So he asked Elking to review the lineup, and they have 2 lineups. The first one, they had Lamar Johnson in it. He looks at it, he shakes his head, he says, this is Elking now, but he couldn't really identify anybody. Takes a break, walks away, comes back, second time, looks at it again, shakes his head, walks away. Third time he comes back and says, I think it was the end guy there. Well, that was not Lamar Johnson that he picked out. So they bring in a second lineup now, and he couldn't identify anybody in the second lineup. So Nickerson then going to take him back up to the homicide room. I don't know exactly where that is. I haven't been to the police station. And on the ride to the elevator, Nickerson tells him, Mr. Elking, I know you know who it was. I know you are afraid. But we're going to take care of you. But you got to do the right thing. You got to stand up and identify the person you saw shoot. And so Elking, and he'll testify, was nervous and said, look, I tell you what, you tell me who they were, and I'll tell you if that's true. And so Nickerson tells him it was number 3 in lineup 1, 4 in lineup 2, and yeah.
Wasn't there any objection to this being an improper lineup as a result?
I don't believe there was.
Justice commentary?
I don't think so, Your Honor. I mean, there were objections, but none of them were sustained. All this information came in.
And this information came in that this might be a suggested lineup.
A suggested lineup? Well, we'll look at the lineups here, Your Honor, in this hearing. There were 4 black guys in each lineup, and I think it's important to know that they all wore dark clothing. No one had a Black Hawk red armed jacket on like we argued about last week. So, but he wasn't able to identify anybody. But on that elevator on the ride up.
Okay, I hope you guys are all taking notes, because I'm honestly a little concerned from what I just heard, if this is in fact how the evidence develops. All right? The police officer actually gave the witness some potential individuals in the lineup. This is the same police officer who evidently knew that Elkin knew the defendant, Mr. Johnson, on a personal level. So he knew this person. He's in the lineup. These 2 numbers that he suggested to Elkin, were one of those numbers assigned to Mr. Johnson?
Yes, Your Honor. 3 and 4 were the 2 assailants. 3 in one and 4 in the other.
I don't get that, how that got back.
Well, they took him up to a room, said, thank you very much. You've got to be able to testify. We're going to give you protection. And Nickerson said, I'll pick you up the next day at 8 o'clock in the morning. Protection turned out to be cash and payments.
How do you know that?
We have records of it, Your Honor.
And was this cash and payments put on the floor before he went back and made another identification?
No, Your Honor. He did not.
This was after.
Yeah. So this is in the evening this is like 9 or.
Be more specific.
Yeah.
Did Elkin know about cash and payments before making identification of Johnson?
He had received no cash or payments before making the identification. He was told that they would put him in a witness protection program and move him out of his house.
Okay.
Now this is late at night, 9 or 10 o'clock at night, at least.
All right. I just need to know context.
So the next morning, Nickerson comes out, picks he and his wife up, and brings them down to the courthouse here. Well, I don't know if this is the courthouse. It was where the circuit attorney's office was in 1994.
Does anybody know if these payments or anything after the fact, did that get into the trial below?
No, Your Honor. We didn't discover it until 2 years ago. That's one of the.
Isn't this something the prosecutor would have known about?
Yes, they knew about it, and I'm just going to tell you how they knew about it. Yes, they knew about it, Your Honor. Absolutely. Isn't that strange that you wouldn't disclose that to the defense? Ever.
How about unconstitutional?
Sure. It's unconstitutional. Pure Brady material. And in fact, we're going to have a witness who was in the U.S. Attorney's Office in the Conviction Integrity Unit who discovered it.
All right. We'll see if you prove that up. Keep marching. Go ahead.
Okay. So the next day on November 4th, Nickerson goes back out, picks Elking and his wife back up and bring them down to the Circuit Attorney's Office to talk to the Chief Warrant Officer, Dwight Warren. Dwight will be a witness for us here in this case. And Nickerson describes the evidence he has to Warren, saying this person was a witness. He picked out, he identified Campbell and Lamar Johnson, and then they issued an arrest warrant and charged him with murder that same day. So after meeting with Dwight Warren, they then took him over to the Witness Protection Unit that same morning. Introduced him to the lady that he'd be dealing with in the Witness Protection Unit, and she gave him $250,000 in cash. What did I say? $250. Yeah, I'm sorry, Your Honor. That would have been a big wad of cash. So $250. Thank you, guys. Anyway, and these payments continued. They paid for a new apartment. They paid for utilities. They paid for storage of some of his furniture, etc. And overall, I think the record shows that he received $4,000+ between that time on November the 4th, 1994, and the time of the trial when he testified in July of 1995. So this was not disclosed at all, and this was discovered late in the game. It's Brady material, and we've talked about it in our motion.
The obvious question that evidently was not asked was, isn't it true that you are testifying today because you worried that the state asked for the money back?
I think that question was not asked because the defense did not know about it.
One of my students has picked up on that part.
Yeah.
Go ahead.
Yeah, you can imagine if you're a trial attorney, a defense attorney, how you would have handled that information, just like you said, Your Honor.
All right, go ahead.
So now, after they're charged on November the 4th, they're put in a holdover cells in city jail. Up to this point in time, the only evidence they have is that Elking made this very, what I call questionable and highly incredible, because I think, as a matter of fact, you will, Your Honor, and that's why we're here, absolutely. But when that night is described, it's dark, there's no light, the assailants are wearing masks and dark clothing, and it all happens in a matter of seconds. It is certainly improbable, if not impossible, for someone to identify the assailant. And we'll talk about that a little bit. So after Campbell and Lamar is taken to the holdover cell in City Jail, a few days later, there was another prisoner who was jailed in the same cell block, not the same cells, several cells down, who came forward and approached the jail guards and said he had information that he wanted to talk to the police about. So the police went and talked to him, and among other things, he said he heard Lamar tell a person by the name of Lamont to take care of the white boy.
Hold on, I didn't quite get you. He heard somebody named Lamont?
Yes.
Not Lamar.
Now, Lamar heard, he heard Lamar tell Lamont,
Okay, so Lamar tells Lamont,
oh, you've got to take care of the white boy.
you have to take care of the white boy.
Right.
All right.
Among other things,
That's what this, I don't think you gave the name of the inmate who heard.
his name was William Mock, Your Honor.
Did you spell that last name for me?
M-O-C-K. M-O-C-K.
So inmate Mock hears
Lamar.
Lamar say he says
To Lamont.
And then what's the quote?
You got to take care of the white boy.
You gotta take care of the white boy. Was Lamont in prison at the time?
Lamont and Campbell, after they were charged on November 4th, were put in the city jail holdovers area, and Mock was in that same area, not in the same cell.
I'm trying to figure out why would, give me some facts
Sure.
to suggest that the defendant would have an expectation that Lamont would be able to, quote, take care of the white boy, end quote.
Don't know. There was no Lamont in jail, Your Honor. That's the problem. That's the point. There was no Lamont in the jail at the
So you
time.
can't even figure out who this Lamont person is.
Correct. Correct.
And I'm going to assume that the white boy is focused on because
Elking.
this is a neighborhood where a, quote, white male would be an unusual resident.
Well, certainly he was. The reason is because Elking, who was the witness to this crime, there are only two witnesses.
Question.
Pardon?
Are there plenty of white guys living in this neighborhood?
Yeah.
That's not-
I don't know how many white guys are in that neighborhood, Your Honor.
So we have a name of who this particular white guy is.
Mr. Elking.
All right.
Yeah, that's a good question. I don't know the makeup of the neighborhood. Okay. I mean, I'm sure it was a mixed neighborhood at the most, but I don't know, Your Honor.
All right, I got you. Sorry, but I want to make sure I
So, Mock,
keep this straight so I
Yeah.
can test your evidence against the evidence.
so it turns out that Mock has a long criminal history, having been convicted in 4 or 5 different states in this country at various times. He was in city jail because his probation that was given to him by a judge in Kansas City, Judge Mason, not you, Your Honor, but a different Judge Mason, had revoked his probation. They picked him up here and put him in city jail. That's what he was doing there. Turns out this same jailhouse informant in '92, 2 years earlier, was in Kansas City jail with a cellmate. He approached the guards in that jail and said he had information about a homicide. He wanted to talk to the jailhouse guards. He told the guards that his cellmate had confessed to him that his cellmate had taken part in a vehicular homicide.
This is another case I've
This is another case in California where Mock, similar to what he had here, came forward to the jail guards and told them that his cellmate had confessed that he took.
Did that prosecutor act on that information?
That information was not provided to the defense.
No, my question was, when I say that the prosecutor acts on that information, did the prosecutor put Mark on the stand in front of a jury to testify that a defendant said, I was involved in the murder?
In the Kansas City case, I think yes, Your Honor.
All right. So you'd already gone through the process once. Now go ahead.
So he does testify in this case. He, in his deposition, he said he'd never been in a mental institution. The prosecution at the trial testified that he really didn't ask for anything. He was just coming forward as a good citizen with the information he provided. It turns out that 3 felonies were disclosed to the
I'm sorry, Mr. White. I just need to make sure we're talking about the same thing, because I asked you some questions about Kansas City.
Yeah, I'm sorry.
First time.
Yes.
And did this person testify in Kansas City?
My understanding is he did, Your Honor.
All right. The court counsel wants to consult with you.
Okay.
Your Honor, I believe that they pled out that case.
All right.
And they pled it out because I think he made a statement that this is what he heard.
All right. So he said it, but it turned out evidently to be true in that case.
The guy was convicted.
Now, in
And
this case,
yeah.
same guy here in St. Louis, same situation, comes up, I overheard this comment. Do you know the physical context? Were they in a cafeteria? Were they in a shower? Where were they when all of this occurred?
My understanding, they were in different cells in the same cell block.
Well, you say different cells. Do you know how close?
30 feet or more, my understanding.
With the allegation that Mr. Johnson was yelling this out?
I think he did say that they were yelling at some point.
But the only person I'm gathering from the way you said it to Overton who heard this was this one mom.
Yes, Your Honor. None of the other people in the cell block had heard it.
What benefit, if any, did Mark receive in Kansas City?
In Kansas City, I think he received he might have received parole or probation. We have those records. Yeah. Do you remember? He received probation, Your Honor.
So he already knew that there could be some benefit from this kind of information.
Right.
Keep going.
So at trial, the prosecution said, what is he going to get out of this? He might get a letter to the parole board, but that's all. He wasn't asking for anything else. That's what the prosecution in Lamar Johnson case told the jury. In his deposition, he said he'd never testified in a case like he did he never been involved in a case like he was in Kansas City, and he said he'd never been in a mental institution. Turns out he was in a mental institution for over a month or more.
Do you know what the diagnosis was?
I don't know what the diagnosis was, Your Honor.
All right.
He also wrote a number of letters to the prosecuting attorney here in St. Louis. He said, I think my testimony would warrant a pardon from the Governor Carnahan at the time. I think I should get probation and parole. I think I should get favored treatment in prison, but I also want to promise that I don't have to go back to the Department of Corrections, even though my probation has been revoked. He wrote a number of letters like that. None of that information was disclosed to the defense. So he expected a whole lot of things.
Stop. I'm dying to ask, who was the prosecutor?
The prosecutor was Dwight Warren. Dwight is retired.
Yeah, I know you talked to him. Keep going.
I think he's going to, we asked him, we don't know how, We asked him, he's going to come to trial. I don't know whether it's going to be tomorrow or Wednesday.
All right.
He's got 135 miles. He's down on Poplar Bluff, just bought a home down there. Anyway, in letters to the prosecution, Mr. Mock referred to Johnson and Campbell as two-bit N-words. So this is anyway.
Lamar said this about Johnson and Campbell.
Mock said that about Lamar Johnson and Campbell.
Johnson and Lamar Johnson and Campbell.
That's correct. Yeah.
That's Main Street.
Okay. I understand, Your Honor. So at trial, Elking testified.
Unless Mock.
Mock
Mock was black or white?
Mock was white.
Oh, he said that.
Yes.
Spirits are a little different. Did that get to the jury?
That did not get to the jury. Those letters were just discovered and didn't get to the jury. Your Honor. So at trial, Campbell testified, Ralph Campbell that we talked about. Mock testified, overheard this stuff in the prison, and Elking testified that he recognized Lamar Johnson as the person he saw kill Marcus Floyd. That was the three witnesses. That was the evidence. Prior to Mr. Elking testifying, he was in the courthouse waiting to go and testify. They took him into a room, and in the room was Marcus Boyd's mother and sister. Mother was crying. And basically, they were telling Mr. Johnson that he needs to go in there, even if he has any doubts, he needs to testify that he saw that he saw the assailants, and he could recognize the assailants, Mr. Johnson.
I'm sorry, I
So
didn't quite get the word. Who was sent in to be with the victim?
Marcus Boyd's mother.
Marcus Boyd's mother.
The victim's mother. Marcus Boyd was the one who was killed.
Right.
Mother and sister, and they took Mr. Elking into the room.
That's what
They took Mr. Elking into the room, and told him basically he was an important witness. He needs to go in that room and make sure he can identify the killer.
So they have Elkin in a room where there's the crying and grieving members of the decedent's family.
Yeah.
In the same room?
Same room. Yeah.
And in that context, they're basically telling Elkin, you've got to make an identification.
Correct. That's my understanding.
Keep going.
So Elking indeed does testify at trial. That was the three witnesses. Ralph Campbell.
So go ahead. So Elkin testifies at trial.
He did.
That person sitting there at the table is the person who fired the shot.
He did.
And did the defense attorney know about this room with the members of the decedent's family?
I do not believe so.
All right.
The defense attorney,
That would have been in the cross-examination of that.
I would think so. Defense attorney David Brunge, who was in the public defender's office, was the attorney representing Lamar Johnson at trial.
All right. So I'm assuming Attorney Brunn is going to be called to testify.
He will, Your Honor. And so Mr. Johnson was convicted, I think, on July the 12th.
Convicted on Elkins, basically pointing the finger, and Mock
Testifying, he heard Campbell.
over testifying about the statement.
Yes.
And what about this statement, I should have let the white guy live?
Ralph Campbell also testified.
Ralph Campbell testified.
Yes. There's two Campbells here. Phil Campbell was one of the assailants. Ralph Campbell was the detective. Gets a little confusing.
And is the only person they identified Lamar Johnson?
Mr. Elkin.
Is that the only person identified as an assailant at trial? Was that the only person Lamar Johnson? Or was somebody identified both assailants?
No. So the next guy that was tried, Phil Johnson. So let's
You mean
Phil Campbell. Sorry, Phil Campbell. So, and thank you. So I think the trial ended on July 12th, 1995, less than a year after the incident. So almost immediately, Phil Campbell hasn't been tried yet, remember? He's waiting trial. So almost immediately, Phil Campbell, who's actually in jail, starts writing letters to Lamar, which we have and you will see, that I'm sorry you're in this situation. You didn't have anything to do with this. It was B.A. and me that did it. B.A. is badass Howard. He will testify also.
She was asked you to repeat that.
James Howard. Yeah, James Howard.
But that was badass Howard.
So you'll see these 4 letters that he wrote within days after he's convicted. This is
Within days after who was
after Lamar Johnson was
after
convicted.
within days.
Within days, he started receiving these letters. He told his,
Did the defense counsel have those letters at that point?
well, remember,
So they could have been given to the court of sentencing.
well, they were written after he was convicted. Okay, and so now you've got,
But before sentencing or after sentencing?
I think before sentencing, Your Honor.
All right, keep
So
going.
what happened is Lamar told his defense attorney about these. They filed a motion for new trial,
Right.
and the prosecution found out about it. Dwight Warren then asked the police to issue a warrant to search Lamar's cell at city jail, and they went over there and they got these 4 letters, among other things, brought them back, and that's how we got them, because they were in the circuit attorney's office, they were in the files. And these letters you will see, Your Honor, where he is basically saying, you know, I'm sorry you're involved in this, you didn't have anything to do with it, it was Howard and myself that did it. I think these 4 letters you'll see, some of the, because there's no motivation for Phil Campbell to tell Lamar that you weren't involved, Lamar, it was B.A. and myself that killed Marcus Boyd. And we will show you those letters, Your Honor. They also are part of the exhibits that we attach to our motion. After the conviction of Lamar, the payments to Mr. Elking and his family stopped. Elking, as soon as he got out of the courtroom, started having second thoughts about testifying that he really didn't see, couldn't really positively identify any of the assailants. So he stopped cooperating with the police. Moved around, couldn't find him, his wife moved around. So they didn't have Elking to testify against Phil Campbell. So Phil Campbell, the following March, Johnson's convicted in July of 95. In March, I believe it was March or the spring of 96, Campbell pleads to a manslaughter charge and gets 7 years. Campbell is dead, is deceased. He's not alive today. He died from an illness, I think, around 2017.
But other than the letters, you have any other statements by Campbell?
By Campbell. He has signed affidavits, Your Honor.
All right.
At least 2 affidavits he signed saying he did it. Lamar did not.
All right.
Elking breaks up with his wife a year or 2 later and goes off on the deep end and commits a bank robbery, and he goes to prison. This is the eyewitness. And in prison, he writes a number of letters to Lamar, apologizing for identifying him, saying, I really couldn't identify you, I apologize for what I did. There's a number of these letters that we'll see in the hearing today, Your Honor.
How you going to authenticate the letters, Jordan?
Elking received them, Your Honor.
So it's gonna be by virtue of did you say the envelope they came in, like you said?
I don't know if they saved the envelope that they came in. These letters also, we have them.
Anything I can at least compare at a layperson, handwriting or anything like that?
There may be, Your Honor. I don't know. I don't know what. Some of the handwriting in these letters are really good. Really, I mean, 10 times better than my handwriting. I couldn't.
It's just that you know what it means to authenticate.
I understand, Your Honor. Yes, I understand.
You don't have the letters that they came in. You do have a witness who says, I received them, all right? And that could be part of a foundation. I'll have to hear all of that.
Yeah.
You have, you know all the different things. Do they reflect information that could have only been known by the purported writer? What attempts were made to verify this? And that the affidavit is a little bit stronger that you have a motive of that affidavit. So that you have less than foundation issues.
So we have.
So we'll see what happens when you try to lay a foundation on it.
So we have the actual witness, Mr. Elking, who will state and identify the letters.
I know it's by its own written document.
Yes, Your Honor.
Okay, that's all.
Yeah. And remember again, as I said in the beginning, Your Honor is entitled to consider all information as well as evidence. The idea was to avoid getting hung up and getting involved in technical evidence that might impede the search for truth.
I don't have to worry about technical, but I have to, I can't go so far that I would consider things that would never have been shown to a jury. When you start talking about absolute innocence, the word is pretty clear. And if you have evidence that if the trial judge knew, if the trial judge was off the case, then you're in the zone. Just like at the trial level, any window, suggestion, rumor, and so on wouldn't hit the floor. It won't hit the floor here. So don't take that standard on evidence and go too far.
Understand, Your Honor. So, as you point out, this is a case that's being tried to the court. And that was part of the statute, not a jury case, but a part of to the court. And that allows you to have discretion and leeway, determine credibility, and use your common sense as a judge, Your Honor, and your experience as a judge. And that's why you're here. And we appreciate that. So, in the end, you have more than common sense, Your Honor, but I'm a big believer in common sense. I'm a big believer in simplicity with getting too complicated. We've handled about 4 or 5 of these cases. As I said, this is kind of a unique case, and it's the only case that I've been involved in where the actual assailants have confessed under oath. And you have all of these other corroborating pieces of evidence that it was James Howard and Phil Campbell, who's no longer alive. The only 2 witnesses was Leslie Williams, who's still living. She couldn't identify anybody. Elking did at trial, but he's recanting that, Your Honor, and I think you'll hear his testimony.
Right.
So I think we'll show you by clear and convincing evidence that Mr. Johnson, he's been in jail for 28 years. It's a long time, is innocent of this crime. And thank you for listening to me. I appreciate it.
Counselor, Officer Attorney General, do you need to give an opening statement at this time?
Yes, I do, Judge. And may I have one moment to clean up the certain attorney's notes?
Oh, yes, please, thank you.
Thank you, Judge, and may it please the court. Why did I let the white guy live? Man, there was a witness. Why did I leave the white guy to live? We're effed because we let the white guy live. Those are Lamar Johnson's words. That's what Detective Campbell, who in 1994 was already a 20-year veteran of the St. Louis Metropolitan Police Department, testified at his trial. And if the court wants, that's found on page 229 of the trial transcript.
Make sure you give me the copy of this, I can see it on the top.
Absolutely, Judge. Would you like it now?
No, just
Okay.
make sure that you do.
Yes, Judge. After Lamar Johnson told those statements to Detective Campbell wondered, what was he talking about? Because he was actually there to talk to him about a different homicide. And Lamar Johnson indicated that he was talking about the murder of his former friend, Marcus Boyd. No one disputes that on October 30th, 1994, Marcus Boyd was shot and killed on his front porch at 3910 Louisiana Avenue here in St. Louis, Missouri. No one disputes that two masked men were the gunmen. No one disputes that James Elking, who happens to be white, witnessed that homicide. But Judge, after you hear the information and the evidence, you will know that Lamar Johnson was one of those masked killers. I should also say no one here disputes that Philip Campbell was the other masked killer. This hearing really comes down to you hearing two versions of events. One version of events, what happened at the trial, what was presented, and what happened in the 8 months between Marcus Boyd's homicide and the trial. The other version is what's going to be presented to you today in this hearing. And I apologize, Judge, over the week at this hearing. And what happened in the 28 years from the trial until this hearing. The question you will have to answer at the end of this hearing, Judge, is which version do you believe? So let me tell you why the evidence and the information will show that what occurred at the trial and in the 8 months from the homicide to the trial is accurate, is reliable, is credible, and it's the truth. It all starts with the law enforcement officers. These were seasoned homicide detectives who investigated this crime. They wrote reports. They wrote what occurred, good, bad, or otherwise. It's in the report. And you will hear from some of these detectives 28 years later that they never threatened anyone in this case. They never bribed anyone in this case. They didn't coerce anyone in this case. They did their job. They investigated the homicide. They found evidence. They found witnesses. They talked to those witnesses 1 time, 2 times. And they followed the leads. And all the leads in the Marcus Boyd homicide pointed to 2 people, Philip Campbell and Lamar Johnson.
You're going to give some evidence as to what those leads were?
Yes, Judge, through what was presented at trial, as well as through the testimony of Detective Nickerson, through the testimony of Detective Clyde Bailey, and also through, in part, the testimony of Dwight Warren, either through direct or cross. But once law enforcement was done with their investigation, they handed this case over to Dwight Warren. Dwight Warren was working at the circuit attorney's office, and he presented to the jury a very straightforward case. There's no frills. One person he did call to testify was a jailhouse snitch. That jailhouse snitch, his name was William Mock. And Judge, he was the epitome of a jailhouse snitch. Of course, he was in jail. He had long criminal history. And he overheard some statements in a crowded jail. Now, you asked, whenever the circuit attorney was giving their opening, where these conversations occurred. And Judge, these conversations occurred while Philip Campbell and Lamar Johnson were in jail cells 6 and 7, and William Mock was in jail cell 10. And through this hearing, you'll see a photograph of just how far away these cells are. But there's something else this court should know. During his PCR hearing, Lamar Johnson actually testified. And he told the court that he mentioned the Marcus Boyd homicide while he was in jail. He mentioned that there was a white boy who lived. His words. And you'll see that through the transcript of that PCR hearing. Yes, Judge.
The way you characterize that, off the evidence that he mentioned the homicide, he mentioned that there was a quote white boy that saw it or something of that nature. You understand how street news works, and if you don't, you should. But so far, you told me things that one could hear that was filtered into a prison on the street. General conversation, street news, stuff I hear on Metro, that kind of thing.
Absolutely, Judge, and I don't disagree with you, and the Circuit Attorney's Office didn't agree back then. William Mock's testimony, it is what it is. He's a jailhouse snitch. And the jury heard all of that. Criminal history, he was cross-examined on conversations that he overheard. Absolutely, Judge. This case does not rest entirely on William Mock. The jury also heard that he received a favorable letter from Dwight Warren to the parole board. The jury heard all of that. The jury gave his testimony the appropriate weight. There's really nothing more to say about William Mock. James Elking, though, the white guy who wasn't killed that night, he also testified during the original trial. And it was no secret that back then, the Circuit Attorney's Office was protecting his life. His name didn't appear in the complaint. His name was removed over 100 times in the police reports. Even the deposition he gave, when called to give a deposition by defense counsel Bruns, he was secret witness Gray. Nowhere does his name appear. And James Elking, he did testify. But he was nervous. He was scared. He was scared when he saw Marcus shot on his front porch. He ran all the way back home. When he got home, he packed up his pregnant wife, he packed up his young child, and he fled. He went to his sister's house. And eventually, through Leslie Williams, law enforcement were able to piece together just who James Elking was and where he was located. And they talked to him. He came in, they met, he looked at photographs that include Lamar Johnson's picture. And there was just something about the eyes that he noticed in the picture. James Elking also saw an in-person lineup that included Lamar Johnson. And initially, Judge, he was so scared that he didn't pick Lamar Johnson as the shooter. Eventually, he tells officers, no, it was the person in number 3. It was Lamar Johnson. James Elking yes, Judge.
Elking did know Lamar Johnson, or did he? If I'm wrong, did Elking know Lamar Johnson?
Judge, the evidence all points to James Elking did not know Lamar Johnson.
All right. Go ahead. So the whole sequence of this is going to be critical. That's why I'm asking you questions.
Yes, Judge, and it is a good question. And it was a question that they even asked back then, if James Elking knew Lamar Johnson before this. And keep in mind, the masked individuals were wearing a mask. In fact, a mask of a similar nature was introduced for demonstrative evidence at trial. And it was found months before in Lamar Johnson's possession. He was stopped by Clyde Bailey.
When you say mask, what kind of mask?
Yes, Judge. I commonly refer to them as ski masks. So it covered
I got you.
everything but the eyes, Judge.
I got you.
And when Clyde Bailey, and again, it was found before the trial, so it wasn't the mask used in the homicide, but when Clyde Bailey stopped the Lamar Johnson, and asked what that mask was used for, Lamar Johnson told him, you know what it's used for. That mask was also shown at trial. But again, James Elking was able to testify at that original trial because the trial was a safe location. He was safe to tell the truth. Lamar Johnson, before that trial, he didn't know James Elking's face. He didn't know the address where he lived. And he didn't even know what he looked like or what his voice sounded like. But over the last 28 years, James Elking left that place of safety. And he entered a world beyond the safety controls of the court. He entered prison. The witnesses the Circuit Attorney's Office will offer for you today are biased. Yes, Judge.
You said Elkin ended up in prison.
Yes, Judge.
Did somebody tell you that he died?
No, Judge. Philip Campbell is deceased.
Philip Campbell's deceased, but Elkin is still alive.
Yes, Judge.
But is anybody expecting his testimony to be true?
I don't want to speak for them, but I would anticipate the Circuit Attorney.
Elking is going to testify, Your Honor.
All right.
Maybe this afternoon we can handle that. He is in St. Louis.
All right, I just need to know, I keep all these names in my head correctly.
I think it's very
Go
important.
ahead.
And Judge, also, William Mock is deceased.
Okay.
Yes.
So Mark and Campbell are deceased.
Correct, Judge.
Gotcha.
The witnesses the Circuit Attorney's Office will present to you during this hearing are biased with motive to lie.
Now that's posing. I need to give my bias in opening statements. What goes to what the evidence is.
Thank you, Judge. I anticipate the evidence and information will show you will hear from numerous gang members that were with Lamar Johnson back in 1994. One name you've already heard, and that's James Howard. James Howard is a convicted murderer, but he did not murder Marcus Boyd. He came forward after he was judgment-proof. He's been convicted for murder, 4 counts of armed criminal action, robbery, and forcible sodomy. He's currently serving life without the possibility of parole, life, and 345 years in the Missouri Department of Corrections. What does he have to lose by coming in here and talking to this court? I also anticipate you will hear from James Elking. Now, at the original trial, he was protected. He was in a safe place. But I anticipate the evidence and information will show that over the last 28 years, Lamar Johnson and people on his behalf, they were looking for James Elking. And eventually they found him. Lamar Johnson's attorneys had numerous constant contact and conversations. His investigators did too with James Elking. James Elking, in those 28 years, sat for numerous recorded statements. He was shown affidavits by other individuals. He was shown recreations of the homicide. He was shown photographs with other people wearing the masks, with other people holding the gun, recreation photographs that were different lighting than what he recalled. And he was told over and over again that he was wrong. Elking and Lamar Johnson also had numerous conversations, back and forth, back and forth. Lamar Johnson told him and gave him an affidavit to sign. And James Elking, when he was in prison, he absolutely did. In one of the letters that James Elking wrote to Lamar Johnson, reads in part as follows. My last question is, when you mailed the first letter to me and sent it to someone in 2 House, again, Judge, they are in prison, they gave it to others in 3 House to give to me. When I finally got it, I was wondering how many people know what's going on and how are they perceiving this or their reaction. Sometimes I just feel like I have to look over my shoulder in here. Lamar Johnson could get at James Elking in those 28 years, anytime and any place, and that's exactly what he did. And that's what the evidence will show. At the end of this hearing, they're going to ask you to believe convicted murderers and gang members, and we are convinced that their evidence is not clear and convincing, and it's not credible. Thank you, Judge. And if you have any questions, I'm more than happy to answer.
Don't have any questions.
Thank you, Judge.
Other than everybody needs to make sure you get me the pages from the transcript, and the affidavit, through the course and conduct of the evidence. See, I'm looking at June right now. You returning from a break, how do you feel?
Yes, Judge. This day is not closed to a break at this time.
That works for us as well, Your Honor.
All right. Well, how much time do you need, Mr. White?
Howard.
All right.
We need to get Mr. Howard, James Howard here. He's in jail.
All right, so we need to get him over. Available to take care of that. He's here? He's back to myself? All right. So he's here. I don't think it's going to change in the next hour that they'll get one of the horrible bologna sandwiches. That's about it. Did you need to move forward now, or?
Your Honor, I prefer to have a well-fed witness to one of the sandwiches.
Okay. Then we will stand down for an hour. Court will be set for 1 hour, man. All right, Division 17 is now in recess.
Got one.